Hello entrepreneurs, I'm Michael Mort with Argent Place Law, the law firm for entrepreneurs just like you. Today I want to talk to you about commercial leases. So your business is growing, that's fantastic. You need to move out of your spare bedroom or garage, or maybe you've been using temporary space somewhere and you want your own space. That's fantastic. So there's a landlord right down the road who has the space almost exactly the size you need and configured the way you want it. Just sign a few documents and you're good to go, right? Well, a commercial lease may be the biggest commitment that your young company is going to make, more so even than hiring people. And I'll tell you why in a few minutes, towards the end of this. The commercial leases are contracts between two businesses. You see, the law and the courts assume that businesses that enter into an agreement, they are going to have attorneys overlooking the agreement so that everybody understands what's going on. That means you are going to be held to every provision that's in this lease. There's no backup laws that are going to protect you in case you made a mistake in signing this. These commercial leases are written by the lawyers of the landlords, always in the landlord's favor, because they're assuming that you're going to get somebody to help you negotiate them, and they're going to have to start giving away some provisions, but they're going to start from a position of strength where they get everything and you get nothing. Okay. Or you get a lot of responsibilities and they get very few responsibilities. All right. So the point is that you have to negotiate. And what's the process? Usually, commercial lease negotiations start with a letter of intent, or LOI. The LOI is a relatively short document that just covers some basics, like a description of the property, where it's located, how many square feet it is, what's the rent going to be, how often it's going to be paid, what's the term, how long is it going to be, is there going to be an option to renew. With respect to that, for example, we had a situation in which it was just the LOI says, the letter of intent just says, yes, there'll be an option to renew. But when we got the lease, it said the option is at the option of the landlord. You don't want that. Obviously, the client that came to us with that one, they had already signed it. They discovered they had a problem, only too late. Anyway, the point is that the LOI is just this short document, and it just covers some basic things. All right, the next step, once all of the basics are negotiated, you're going to get the lease itself. You think 2 pages, you like short contract, you think that would be enough, cover the basics? No. That commercial lease is going to be probably at least 40 pages long. We've seen commercial leases as long as 60 pages. It's going to contain provisions you had never thought of about what you're going to have to be required to maintain, how much you're going to pay the landlord for increases in their expenses, like if their property tax bill goes up, or if they need to hire more people, or just want to hire more people, or give a raise to the people that they actually already have, or they want to improve the building with capital improvements. You're going to probably have to pay a portion of all of that kind of stuff. It's also going to list the things that you're responsible to maintain and what the landlord's going to be responsible to maintain. Like I said, the landlord's going to take on responsibility for very little. So you might have to take care, for example, of the heating and air conditioning system that heats and cools your space. Recently, actually several times, we've discovered situations where the heating and air conditioning system is shared with the other tenant, at least one other tenant. So you're gonna, if that's the case, you better know about it and be prepared for understanding what your responsibilities are going to be and how you're going to handle the other tenant, or see if you can shift the burden, that risk back onto the landlord. Things like parking, and you're going to be responsible for getting all of the permits to make sure that there's enough parking and that your use of the space is permitted by the county or the city. Tremendous number of provisions. Insurance, how much insurance you're going to be required to carry, for example, and what kinds of insurance. And the landlord's going to, I could go on and on. Anyway, there's a lot of stuff in there. But even beyond all of that, there's all that stuff that's at the end of every contract that you say, oh, that's just the boilerplate. Oh, I can skip over that because my eyes are glazing over already. You can't do that because there's important stuff in the boilerplate. For example, indemnification. The landlord's certainly going to require you to indemnify him against any of your misdeeds or the misdeeds of your employees or customers, but he probably hasn't written in an indemnification clause that makes him responsible for anything. Make sure you make that bilateral if you can. What happens if there's a war or riots or flood and your space becomes unusable? There's some part of that might be covered in the contract, but not all of it. You better make sure you understand what options you might have in that respect. There's something called a force majeure clause that you may or may not be able to negotiate to get into the middle of it. Okay, and then lastly, there'll be a document at the end, and it's going to be like this. You're thinking, oh, I'm an LLC, a limited liability company, or I'm a corporation. My personal assets aren't at risk if I sign this contract, just the assets of the company. But no, because landlords are smart enough and they have good lawyers. They know what a limited liability company stands for, and they don't want to be holding the bag if your company goes bankrupt. They're going to want to come after you personally. So you're going to have to sign a personal guarantee. Almost surely they're going to say, if the company can't pay, we're going to come after you personally, your family assets, and they're going to review what's your family assets before they'll even be willing to sign the lease. In fact, it may even say, we can even bypass the assets of the company and go directly to your personal assets. You better make sure you understand what all of that's all about. So in summary, commercial leases don't have the kinds of protections that residential leases do. You need to understand what's going on. You really need to hire somebody who is willing to go over every single sentence of that lease, understand it, and make sure that you understand what your risks are. I'm Michael Mort, the founder of Argent Place Law, where we're the law firm for entrepreneurs just like you. We're looking out for you, on behalf of you, and represent you in your business relationships, like with your landlord. Until next time.